All right, guys, time to finish up this answer that Dick's lawyers have filed, which is, I mean, it's not actually an answer. This is the motion to dismiss based on the 4 different grounds. I've got it pulled up here. We left off right at the end of point 1, which is about halfway through the document, and we're going to pick up at point 2 in just a second. Got a couple questions that I wanted to address right up front. This has come up a couple times. This is a stand-in wedding band. I have a couple of different ones, but they're all this color. I have a real wedding band too, but that one hurts if you ever have to grab anything heavy because it's titanium and it pinches on a nerve right here. So I had this one ever since I started, doing any sort of physical exercise with vigor, as opposed to just pretending. So that handles that, hopefully. I've got this new little setup going here, and hopefully that'll help you guys see the document a little bit better if you're not on full screen. Again, I welcome the feedback and really appreciate all the constructive criticism I've gotten. Hopefully there's not an audio gate on this time. I'm trying new software again. So if something just royally screws up, let me know. That's fine. I'm still new at this, but it's a lot of fun. The next question was related to, I mentioned anti-SLAPP laws, and I got a question in the comments just to kind of talk about what those are. So SLAPP is an acronym, and it stands for Strategic Lawsuit Against Public Participation. So there are lawsuits that are raised for the sole purpose of knocking down free speech, right? And I mean, this one looks a lot like a lawsuit that is being filed specifically to try and stifle protected free speech activity. And it looks like it's being done for the purpose of punishing the speaker, or speakers as they were, right? Pretty much everything that's in the complaint is protected speech. It'd be really hard to make a case on defamation on any of it because most of it is opinion-based. And any reasonable person who looks at even the stuff that's in the complaint would have to conclude that this is opinion, not statements of fact, and therefore it's really hard to show defamation or even any of the other stuff. The speech it's all pretty protected. So anyway, what you do is you get these people, right, who maybe are failures at other things, and then they get mad that someone says something, and they don't like what they say, but they can't stop it. So they file a lawsuit instead, and the purpose of the lawsuit is to either maybe win a judgment, but probably not. Maybe it's because filing a lawsuit can be really, it can be really expensive, but it can also be pretty inexpensive if you say, write the lawsuit yourself, and then you just maybe have someone file it for you really inexpensively. You can do that, and you can file a lawsuit pretty much for some filing fees and maybe a couple $100s to an attorney. You don't really need an attorney to file a lawsuit. I mean, you should get one. If you actually have a lawsuit, right, you should get an attorney. But if you find someone who will file something for really cheap for you, there's some attorneys out there who will do, free complaints because the only cost of entry is the filing fee with the court and whatever time the attorney puts in. And if they figure they can force maybe a large company that someone in the lawsuit works for to make it go away because it'd be cheaper for it to go away than to fight the suit, right? Maybe an attorney would take that case, even though they know that the suit has no chance of winning in court, but they're just hoping for an easy settlement, right? Like that type of stuff happens. I don't know where that type of stuff happens, but it is possible to find attorneys who will tread that ethical tightrope and take cases that they know they aren't going to win, and they'll do it on a contingency maybe with a very minimal upfront fee. But the hope is that they get a big chunk of like 30, 35, 40% of whatever they do happen to recover. So if maybe some of the plaintiffs, like I said, maybe a large, well-established employer of one of the defendants, if they were to happen to settle, and maybe pay out like $10,000 or something to make this go away, because they might end up paying their attorneys more than $10,000. If they can make it go away really cheap, at least as far as they're concerned, right? Then the attorney gets a couple $1,000s for really not a lot of work, and then the plaintiff gets whatever. So there are some temptations out there for attorneys to do this, and for plaintiffs who maybe can't compete very well in the public sector, trying to punish their competition, or in the private sector, I should say, that trying to punish their competition through a lawsuit, because it may not cost a lot to write a 53-page complaint if you do it yourself, but it costs a whole bunch of money to hire someone competent to defend it, and you have to go through all of the motions and make sure your end is covered. Otherwise, you end up in default, and you might end up with some stupid award against you. I'm not saying that's what happened here, but maybe. So anyway, SLAPP lawsuits, or I guess that's a SLAPP lawsuit, right, is a strategic lawsuit against public participation. Knock someone out of the free speech zone. An anti-SLAPP law allows for recovery when you can show, you use a motion to dismiss, a SLAPP motion to dismiss, right? You say, this lawsuit should be dismissed because it's obviously a SLAPP action, and my client shouldn't have to bear that burden because that's unfair. So you get the motion to dismiss. If you're successful, you can then countersue the other party in an anti-SLAPP lawsuit that follows up, or a slapback is what they kind of call it. Anyway, when you recover in that lawsuit, you recover some damages, but mostly you get your attorney's fees for the other motion, and I think for the slapback too. It's state dependent. Here's the gist of everything. California has like the strongest anti-SLAPP laws in the country. Why? There's a lot of reasons, but you're talking about Hollywood existing in California, right? Lots of speech creators exist in California. Facebook's in California, Google, Apple. Lots of platforms that provide for speech. I'm assuming Twitter is. Patreon's in California. Lots of these platforms that provide for the ability to speak are centered in California. They go through lawsuits all the time. But also Hollywood and television production. These guys are going to be creating stuff that is protected speech, and then and a lot of it is created in California. So California has developed strong laws to protect against these lawsuits, mainly so that people and companies don't go bankrupt for just expressing their ideas and trying to create something. New York has a very weak anti-SLAPP law. They have one, but it is not as strong as California's. It's not as thorough. It doesn't guarantee the payback of attorney's fees and stuff like that. So we don't have a SLAPP motion to dismiss here in this case yet. I don't know if one of the other attorneys might try that. But that's what the anti-SLAPP is. That's probably a big reason the suit was filed in New York. They probably decided they could anchor it to New York through Asterios and Weber Shandwick and have that be reasonable. That's short-sighted, right? Maybe, they can still dismiss this against all the other defendants based on venue and jurisdiction. And they can probably dismiss it against Asterios too on other grounds. But I think that Maddox and Landau, if they even discussed this lawsuit, or maybe Maddox just did a little research online, they determined that the SLAPP laws were stronger in California, produced a much higher risk for the suit being brought in California. Because I tell you what, if this was in California, I would expect an immediate slap motion to dismiss, and then a slapback lawsuit, and then Maddox is paying big dollars to Dick for that. So I hope that helps with the slap laws. I apologize if I use shop talk or acronyms from the legal world. It's kind of, you kind of just get in the habit of that. And if you need anything sussed out, like I said, drop a note in the comments, and I'll either put it in a video or I'll answer in the comments if it's quick. A bunch of people have asked if this is dismissed in New York, can Maddox bring this in California? Yes, I think for the most part he can. But will he? And I mean, the cost to bring it in California is a lot, and the risk is really high based on the slap stuff. There's a reason he didn't bring it in California in the first place, because it's the only state that it makes sense to bring this suit. The only state is California. I mean, if he wanted to just sue Asterios, he would do that in New York, maybe. But yeah, I mean, it doesn't make any sense to have the suit there in New York. It makes a lot of sense to have it in California, and I'm assuming that anti-slap is why. So yeah, he probably could bring it in California, but we're talking about a significant financial cost. They'd have to rewrite the entire complaint. They couldn't use almost any of it because as badly as it's drafted, it's still based on New York laws, and they would have to redo all of that stuff to make it proper. Now, some of the fact claims they could keep, but all of the causes of action they'd have to redo and re-research, and you're just talking about a bunch of work or a bunch of money, one of those two things. And then again, the risk of slap. So I don't think he will, but I don't know. He does. He and his followers claim that he has infinite money to throw at this stuff. I don't know. I'm not his accountant. I don't care. He can waste his money all he wants. I hope if he does bring it in California, he gets slapped back and has to pay for all of this nonsense. But we'll see. Time will tell. So tonight I decided to go. I've got these whiskeys that I got at a charity auction. I think I mentioned them before. More appropriately, my dad bought them for me for my birthday at a charity auction. Thanks, Dad. This is a Wisconsin wheat whiskey. It's a little harsh, but I like it. It's from the, I got these glasses too. It's from the 45th Parallel Distillery. They are not a sponsor. This is not an advertisement. Just letting you guys know what I'm drinking tonight, because some people like to know, and that's how it goes. So anyway, let's get on with this little document here. Just a second, let's start this off too. It's got some oomph. It is not smooth like Scotch, man. But it's good. It's got a good flavor to it. A little sweet there at the end. All right, so we're at point 2. And this is, a couple people mentioned that this is kind of where it gets interesting when they were reading the document. And I agree. At first point, the jurisdiction, notice that first point is 13 pages. And the reason why is because it's really important that they lay out that argument very thoroughly and point out that none of these, they're hammering it home, right? When you've got a legal document, and we're talking about a lot of argument occurring in a memorandum of law, when you've got all that argument and you see big giant sections of it, it's because the attorney is really hammering the point home in the hopes that it's very persuasive, and they think usually you put your strong point forward. And I don't think that it's particularly stronger than these others, although it really might be the strongest point that they have. But like I said in the last video, any one of these 4 reasons for dismissal ends the lawsuit, and that's good. But they really focused on that jurisdiction one, and they did a very thorough job, and they really want to let the court know that the court has no business dragging Dick Bozer or Foundation Digital in front of, in front of the court. That was weird. I couldn't figure out how to say that without saying court twice. Sorry. So anyway, point 2. Oh, and I did get, I got a little more feedback from one of the viewers. He suggested I maybe not read through the citations and not read through the statutes. So I'm going to try that on this document. It's a habit, right? When I read a legal document, I have to note the citations, and I have to research them, because that's how it goes. So I habitually just kind of notice them and read through them. But I hear that can be a little tedious. And if you guys aren't looking up these laws and researching them, that might be tedious for you. So I'm going to try and skip the citations. But I mean, if you're curious about any of this stuff, check in the documents. And again, if you're curious about how a particular law works, I've said the whole time I'm not a New York attorney. I can't advise on how these laws work in New York, but I can give you some ideas, and I have research tools to help me look it up and see. So I'm happy to answer questions about that. Just drop them in the comments. But I'm going to try and avoid citations, just to kind of move things along and maybe make it a little bit more narrative feeling. I don't know. But these sections should move a little faster if I can ever start. So the complaint should be dismissed based on improper service. And this, my friends, is funny. So even if personal jurisdiction were proper, which it is not, the complaint should still be dismissed as against Bozer and Foundation based on improper service of process. Okay, see, how do I skip this citation? CPLR 313 provides that service, quote, may be served with the summons without the state, in the same manner as service is made within the state. Service upon a natural person is governed by 308. Plaintiff's affidavit of service purports that Bozer was served pursuant to 308, which provides that service may be effectuated, quote, by delivering the summons within the state to a person of suitable age and discretion at the actual place of business, dwelling place, or usual place of abode of the person to be served, and by either mailing the summons to the person to be served at his or her last known residence, or by mailing the summons. Oh, goodness. I did not catch this originally, because I don't know anything about Foundation Digital or their office or their working environment or whatever. But basically, as we're going to get to here, they didn't deliver it to Foundation Digital. They delivered it to a UPS office where Foundation Digital purportedly has like some sort of delivery box where they can accept mail on behalf of the company. And then that way they maybe, I'm not 100% sure, but I get the impression from the affidavits that they don't have a physical building. It's basically guys working out of their homes. Plaintiff's affidavit of service on Bozer purports that he was served at 23890 Copper Hill Drive, Box 216, Valencia, California, 91354, by delivering the summons to a manager at the UPS store named Ray M. And this is just funny that anybody thought that this was okay. However, this attempted service on Bozer fails to comply with 3082. The UPS store to which summons was delivered is not Bozer's actual place of business, dwelling place, or usual place of abode. So basically, Bozer doesn't work at the UPS store or live there or make it his habit to be there. As such, the service is improper and the complaint must be dismissed as against Bozer. Same exact thing with Foundation. They served the manager of a UPS store thinking that that was acceptable service. And I can't for the life of me figure out why they would do that and why they would think that's okay. I mean, Landau is licensed in New York. He filed these documents. He looked at this and said, yep, that's right. It's crazy. Whew. Okay. The affidavit of service on foundation. I'm skipping the block quote here because it's boring. The affidavit of service on foundation affirms to the same defective service that was made on Bozer. The affidavit of service does not affirm that the recipient of the service was in fact a member or manager of foundation or any other person who is authorized to accept service on its behalf. Nor could it be as none of these people are the UPS store that was served. Foundation Digital is the agent for service of process, Business Filings Incorporated, which is a matter of public record through the Secretary of State. And that's right? Like you can go typically to any Secretary of State website in any corporation, LLC, partnership that is filed with the Secretary of State has on record who can accept process for the business or where you can serve process. Either there's a registered agent or there's a registered process server. Any of these things are findable because you have to be able to sue a company. And if there's never anyone who can accept service, that's not acceptable. So the Secretary of State, this is part of what state governments do, is they catalog all the businesses in the state and allow you access so that you can find out how you can come into contact with these businesses in an official capacity. As service on Foundation Bozer were improper pursuant to the CPLR, this action must be dismissed as against them. In the alternative, Foundation and Bozer respectfully request a traverse hearing on this issue. So this one, point 2 here just is for Bozer and Foundation. I believe Dick was personally served on his service, so he doesn't get to use this same excuse. I don't think that. Oh my gosh. I don't think that matters. Actually, it doesn't matter because the other 3 points, have are really, really strong arguments again. But Bozer and Foundation, absolutely. It should be dismissed against them easily. I mean, it already should, as they have no tie to anything that's happened in this suit, but especially because of the poor service. And again, Maddox, if you are actually paying Landau and he's actually doing this, time to think about what you're paying for, buddy. Point 3. Plaintiff's complaint should be dismissed pursuant to CPLR 327. In the unlikely event that this court finds there is some basis for personal jurisdiction, which, as set forth above, it should not. And I want to point out that in the complaint filed by Maddox, it says as set forth above a lot, but it's actually not set forth above. Here, obviously it is. It is set forth above very well. So, good job. Good job using that correctly as opposed to Maddox and Landau, who did not. The action should still be dismissed based on the doctrine of forum non-conveniens, which, as I said before, inconvenient forum, non-convenient forum. That's the fun Latin. That's easy to remember. Pursuant to CPLR 327, quote, when the court finds that in the interest of substantial justice the action should be heard in another forum, the court, on the motion of any party, may stay or dismiss the action on any conditions that may be just. In Islamic Republic of Iran versus Pahlavi, the Court of Appeals set forth the framework for a forum non-convenience analysis under which a court may stay or dismiss an action, quote, where it is determined that the action, although just jurisdictionally sound, would be better adjudicated elsewhere. In making this determination among, quote, the factors to be considered are the burden on the New York courts, the potential hardship on the defendant, the unavailability of an alternative forum which plaintiff may bring suit. Quote, the court may also consider that both parties to the action are non-residents and that this transaction, out of which the cause of action arose primarily in a foreign jurisdiction, no one factor is controlling. So there's not a what's called a bright line rule. There's not an immediate one and done sort of thing, factor that you can point to, but it's kind of a totality rule where courts are supposed to just determine how reasonable it is to have this thing in New York. It's not reasonable. That's obvious. Every witness is in California just about, except for Asterios and Weber Shandwick. All the damage that's alleged would have only taken place in California, not New York. The plaintiffs are in California, not New York. No one's in New York except for Asterios and Weber Shandwick. That's literally it. And it does not make sense to have them be the locus of this suit. Even according to the complaint, Asterios' section is much smaller than Dick's. The locus of everything is California. So, okay. I'll read this block quote because it's good. In Varconi v. S.A. Empresa de Vallecano Aria Rio Grandense. All right. Court of Appeals held that our courts, however, are under no compulsion to add to their heavy burdens by accepting jurisdiction of a suit between non-resident parties on a cause of action having no nexus within this state. That's what I just said, right? Question whether such a suit should be entertained is one which in general committed to the discretion of the courts below to be exercised by reviewing and evaluating all the pertinent competing considerations. Among the pertinent factors to be considered and weighed in applying the doctrine of forum nonconvenience are, on the one hand, the burden on the New York courts and the extent of any hardship to the defendant that the prosecution of the suit would entail, and, on the other hand, such matters as the unavailability elsewhere of a forum in which the plaintiff may obtain effective redress, and the extent to which the plaintiff's interests may otherwise be properly served by pursuing his claim in this state. Effective redress can be provided in California if the claims are valid. Actually, probably only in California. And all of the evidence is there. You'd have to fly everybody out to New York. Imagine if this is a week-long trial. The lawyer for Maddox, I think, he's maybe he's in New York right now. I don't know, but he's partly based in Michigan. So who knows? Who knows what would be more convenient for him? But Maddox would have to fly to New York for his own court hearings. I mean, you could have multiple hearings over the course of a year. That means you got to fly whoever out each time. It's a huge cost and a huge burden. And what if a plane is delayed and then a court date gets delayed and then everybody gets screwed up? What if there's snow? All of this stuff makes for New York to be a terrible choice when no one's there. The First Department has also held that for matters which involve out-of-state parties, that it is, quote, well settled that acceptance of a suit between non-resident parties based upon an out-of-state tort is appropriate only upon showing of special and unusual circumstances. Quote, it is generally the policy of the courts of this state, in the absence of special circumstances, to reject actions between non-residents founded on tort, where the cause of action arises outside of the state. For cases that involve a single party in New York, the Court of Appeals, now mind you, this doesn't involve, well, I guess it kind of does, has held that the application of forum nonconvenience should turn on considerations of justice, fairness, and convenience, not solely on the residence of one of the parties, right? Not just because Asterios is there. Although such residence is, of course, an important factor to be considered, forum nonconvenience relief should be granted when it plainly appears that New York is an inconvenient forum, that another is available which will best serve the ends of justice and the convenience of the parties. Look, they can bring this suit in California. If they want to sue Asterios in New York, sue Asterios in New York, not everybody else. But you shouldn't sue Asterios at all because you're going to lose. And they get to the argument now. So again, like I said, legal writing course and effective persuasive paper course is the IRAC format. Intro, rule, analysis, conclusion. So now we're in analysis. Analysis or argument, however you want to look at it. First, there's not a single New York domiciliary between the plaintiffs and the motion defendants. In fact, out of the 10 named defendants of this action, only 2 appear to actually be in New York. As set forth above, plaintiffs are alleged to be residents of California. Motion defendants are similarly not residents of New York. That's good whiskey, man. As held by the First Department in Healy and in Sanazari, the court strongly disfavor entertaining actions that are between parties not domiciled in New York. Here there are no extenuating circumstances pled or that appear to be present that would suggest this case being heard in this court. As set forth above, plaintiffs have failed to allege any facts that would support the inference of activity by motion defendants in New York, or that caused an injury to a resident of New York, or caused any injury that was suffered in New York. Plaintiffs' only alleged connections to New York are unsupported conclusory statements. Statements. In addition, it would be extremely burdensome for the motion defendants to have to defend this action in New York, as it will require travel to New York when they work and live in California and Nevada, respectively. Moreover, allowing this case to proceeding New York, remember what I said about lawyers getting tired, may prejudice the motion defendants' ability to secure witnesses, as many of the parties and witnesses reside in California. And in fact, I can't think of a single, I mean, even Heather, right? Heather probably resides in California too, so Maddox would have to pay Heather to come into court. Wouldn't that be great? God, if there would be one thing rewarding about this going to trial, it would be a demand for the identity of Heather and to drag Heather into court as a witness. I mean, that would be just fantastic. And to depose, or if you can't get her in there for a witness, to depose her, get a deposition, right? That would just be great. Gosh, there could be some funny things. There's no connection with New York. This court should dismiss this action. This is especially true where an alternative forum exists. While such availability is, quote, a most important factor in this analysis, the Court of Appeals has emphasized that it has, quote, never held that it was a prerequisite for applying the convenience doctrine, but rather a, quote, pertinent factor. Given the physical location of all the parties, as well as the potential witnesses to this matter, California is a much more suitable location for this matter and is appropriate alternative forum. Plaintiffs in Herrera are domiciled in California. Foundation is also a resident of California, and even though Foundation and Bozer have nothing to do with the wrongdoing alleged and should not have been sued in the first place, California would be a more suitable forum for this dispute. Good job. Point 4. Complaint should be dismissed pursuant to CPLR 3211A7. This is the failure to state a claim. And I think after the jurisdictional argument, this is the second strongest point. And if you've got multiple points, putting your strongest one first is good. Putting your second strongest one last is also good. Sometimes you want to invert those. Depends on what you do. But, you know, bookend it with your great arguments, and then if your middle arguments aren't as good, or aren't as strong, or aren't as fact-specific to the case, they'll just remember your opening and closing being great. No one remembers the middle of anything. So they have to go through, this is a little bit longer, because they have to go through, you know, all 8 of the allegations. And they get to group some, but here we go. Plaintiff's invasion of privacy claim fails. Yep. Sections 50 and 51 are, quote, to be narrowly construed and strictly limited to non-consensual commercial appropriations of the name, portrait, or picture of a living person. In addition, sections 50 and 51 of civil rights law do not apply to reports of newsworthy events. And, quote, a performance involving comedy and satire may fall within the ambit of the newsworthiness exception, even if the performance is not related, quote, to a legitimate news broadcast or event. I covered this in a previous video. This argument is spot on. Here, plaintiff's claim must fail because none of the motion defendants utilize either the plaintiff's name, likeness, portrait, or picture within the meaning of those statutes, as any alleged use was not for the purpose of advertising or trade. Again, Maddox's argument in his complaint is that tweets amount to commercial advertisements and trade. It's not how the law is written. Like, incidental things which can boost revenue aren't considered commerce or trade, right? Those are incidental things which might boost revenue. That's a discussion. Otherwise, like you talking to a person on the street counts as commerce or trade or advertisement if you mention a business or product that you produce. And that's not necessarily true. Networking with people, or even just saying hello and they ask who you are and you're like, oh, well, hey, I'm that guy who invented toilet seats. You're not selling toilet seats just by having a conversation that talks about your background. They're talking in this statute, as I said before, really about very specific advertising and solicitation publications, right? Like we're talking about flyers, news, you know, ads that you put in a newspaper. The cases that exist that are successful about this are famous people's images being used to sell a product, right? Like Homer is Mr. Sparkle or whatever from Japan. That's what they're talking about. They're not talking about In this episode, we talk about why Maddox is a douche. That's not the use of Maddox. Okay. Sorry. That's not an advertising use of Maddox. Okay. Yeah, to be used for advertising purposes, quote, the use must appear in or as part of an advertisement or solicitation for patronage. As an initial matter, the vast majority of the allegations of using plaintiffs' names appear to be comments on Twitter, Facebook, and other online forums. Talking about someone on a public forum cannot constitute... There's an errant comma here. That's a weird comma. Cannot constitute an advertisement, as it is not on a solicitation for patronage within the meaning of those statutes. Oh, that little beepy thing's annoying. Even if plaintiff were able to argue that there was a type of commercial element to such use, it would only be incidental or ancillary, and as such, not actionable. Costanza versus Seinfeld. A couple people pointed this out on Facebook and stuff, and I will do a video on Costanza versus Seinfeld, and I'm going to see if I can get a hold of the actual complaint, because from what I've just briefly read about it, it looks like it's maybe close to as ridiculous as this, and it might require a full complaint breakdown as well, because it's probably funny. Even though it's not written by, anyone funny, it's written by an actual guy named Costanza. In addition, whereas here plaintiff is a public personage who hosts his own online presence and or an actual participant in a newsworthy event, such as the publication of his book, the use of his name or likeness is not for purposes of trade within the meaning of Section 51. Moreover, any alleged use of plaintiff's name on the podcast fell under the newsworthy exception as comment or satire, and as such are not actionable. Furthermore, plaintiff's allegations regarding the use of alleged caricature of Uzunian is also protected artistic expression. This is from Altback versus Coulon. It has a good parenthetical. There's a well-recognized exception for works of art and, quote, advertising that is undertaken in connection with the use of with a use protected by the First Amendment, holding that caricature does not fall within the meaning of the statute. I mean, devastating. This is a devastating case for the only potential claim where you could say that Maddox's image or namesake was used in an advertisement was the Road Rage California thing. Granted, that should be dismissed because it wasn't in California, but when you have a case that specifically says, yeah, caricature doesn't count, dummy, then that's great. Good job. I love that you found that. These statutory provisions prohibit the use of pictures, names, or portraits, quote, for advertising purposes or for the purposes of trade only and nothing more. Whereas here, plaintiffs seek to prohibit protected conduct, this claim should be dismissed. B. Plaintiffs failed to state a claim for defamation. Yeah. Quote, slander per se is any oral statement which relate to any one of the following. Statements charging plaintiff with a serious crime. Statements that tend to injure another in his trade, business, or profession. Statements that accuse plaintiff of having a loathsome disease. Or statements that impute that a woman is unchaste. Libel per se is a writing which exposes plaintiff to public contempt, ridicule, aversion, or disgrace, or induces an evil opinion of him in the minds of right-thinking persons, and to deprive him of their friendly intercourse in society. This is what I talked about, I think, in the 10th video. It's all getting so fuzzy these days. Yeah, that's should be, because I think that was cause of action number 2. He claimed libel and defamation per se. Very specific. Very specific. So, quote, the elements of a defamation claim are a false statement, published without privilege or authorization to a third party, constituting fault as judged by, at a minimum, a negligence standard, and it must either cause special harm or constitute defamation per se. Now, they're not going into the further defamation argument, which is that defamation against a public person becomes an even higher bar, or in a matter of public concern. Maddox is arguably a public figure. I mean, that might be charitable, but he does. He did at one point have over 300,000 YouTube subscribers. He's cited by, to his own braggadocious way, he claims he's cited by news stories from time to time. He's banned from Apple stores, all that stuff. Very, very good argument can be made that Maddox is a public person within the meaning of defamation, and therefore has a much, a laughably higher bar for defamation. So, but you know, we'll see what they do here. CPLR 3016A requires that in a defamation action, quote, the particular words complained of, be set forth in the complaint. If you notice in the complaint, that doesn't happen at all. The complaint also must allege the time, place, and manner of these false statements and specify to whom it was made. Here, despite plaintiffs' repeated vague, self-serving, conclusory allegations that the Herrera and Foundation published defamatory statements. They should have just said motion defendants, but they probably changed it because maybe Bozer isn't accused of that. And reprehensible, vile things such as having sexually transmitted diseases and encouraging other violent acts that constitute slander or libel per se. Plaintiffs have not specifically alleged any statements made by Herrera or Foundation to this effect. Oops. In fact, plaintiffs have not alleged any statements that were made by Foundation at all. Moreover, the only statements plaintiffs have alleged were made by Herrera are not only not libel or slander per se, they're likely not even actionable. When actually reviewing the statements that plaintiff alleges were made by Herrera, not third parties, the alleged statements appear to be nothing more than opinions that, in context, would be perceived as, quote, rhetorical hyperbole or a vigorous epithet, which is not actionable defamation. Here's a quote. In evaluating whether a cause of action for defamation is successfully pleaded, the words must be construed in the context of the entire statement or publication as a whole, tested against the understanding of the average reader, and if not reasonably susceptible of a defamatory meaning, they are not actionable and cannot be made so by a strained or artificial construction. Courts will not strain to find defamation where none exists. Loose, figurative, or hyperbolic statements, even if deprecating the plaintiff, are not actionable. Anyone who listens to an episode of The Dick Show, anyone who listens to an episode of The Dick Show, when you're looking at the entire publication as a whole, knows flat out that these are just insults, man. They're just making fun of you. And you deserve it, you bald dummy. I mean, come on. You do the same thing to people all the time, or you did. I assume you still do. I don't listen to your show, though, because it's bad. Courts in New York have routinely held on online forums are venues where citizens may participate and be heard in free debating involving civic concerns, and that such forums are the newest form of the town meeting. Shameless plug, I'm going to have a video coming out about this soon, where online forums, I don't know that they're going to be able to ban people and censor speech the way they do for as long as, for forever. I think that's going to change, and or they're going to have to change the manner in which they do it, or the manner in which they choose what content gets blocked. Anyway, there's going to be a video about First Amendment in private forums coming out at some point, when I get around to it. In this context, falsity, quote, falsity remains a necessary element in a defamation claim, and accordingly, quote, only statements alleging facts can properly be the subject of a defamation action. Right, I talked about this in number 10. It can't be an opinion. It has to be a factual statement. You have to say, so-and-so is something, and it has to not, it has to be factual. If I say that, Anthony Weiner's a pedophile, right? Because I think that him texting nude pictures to underage girls, or texting lewd messages, or whatever he did, I don't even necessarily remember exactly. It doesn't matter. It doesn't matter at all what he did. If my perception that I'm relying on is that I believe that he was sending lewd messages to underage girls, and therefore I call him a pedophile because I think that's an opinion. I'm not saying a factual statement that he actually sleeps with children in an illegal manner. I'm just saying that, my opinion of his actions seem pedophilic. that may be damaging to him. It's not necessarily a statement of fact. And they would have to consider a lot of things. But, you know, I don't know. It's defamation's really, really tough for all of these things. You have to actually be trying to paint someone in a negative light using false statements. A fact, like a factual false statement. Anyway. Here, Herrera's alleged statements in paragraphs 26, 29, 34, 35, 38, 107 of the complaint are no different than the above statements were held to be not actionable opinions and or would be perceived as rhetorical hyperbole. All of these alleged statements appear to have been copied from Twitter, Facebook, or other online forums and would readily be perceived as expressions of opinion which are not actionable. As held by the Second Department, this conclusion is especially apt in the digital age, where it has been commented that readers give less credence to allegedly defamatory internet communications than they would to statements made in other milieus. Milieus? Come on. This is why I hate, like, courts, right? Why wouldn't you just say in other forums or mediums? Anyway, in other milieus. Plaintiffs have failed to plead statements that constitute defamation per se, or even defamation, in that they have failed to allege any specific statements. Not even one, by any of the motion defendants that allege facts that plaintiffs claim are false. To the contrary, all of the statements alleged to have been made are nothing more than non-actionable statements of opinion upon which plaintiffs cannot maintain a cause of action for defamation against the motion defendants. Boom. Dismissed. Plaintiff's third cause of action for misappropriation is preempted by sections 50 and 51, and this is a good catch. It is well settled that, quote, New York does not recognize a common law right of privacy. As such, the exclusive remedy for non-consensual commercial use of plaintiff's name and likenesses is section 50 and 51, the civil rights law. Quote, there is no independent common law cause of action, the right to privacy or publicity. Quote, New York courts have indicated clearly that the civil rights law preempts any common law right of publicity action. As plaintiff's third cause of action for misappropriation is premised upon the alleged unauthorized use of plaintiff's name, photograph, image, and or likeness for commercial purposes, this claim is preempted and must be dismissed. Should have done your research. That's right. That's in the text of 50 and 51, I'm pretty sure. If not, it's in the comment. Whew. That's good whiskey. Okay. D. Plaintiffs failed to state a claim of intentional infliction of emotional distress. Getting slurry, sorry. I'll clean that up. To adequately state this claim, plaintiffs must plead extreme and outrageous conduct. And by the way, extreme and outrageous conduct is extreme and outrageous conduct. I wish I could articulate easily how extreme it has to be. Very extreme. Just insulting someone, even using naughty, profane words. Usually not extreme. Like, oh man, it has to be a pattern of seriously outrageous conduct. Filing a bunch of false police reports. Oh, by the way, taking one of the plaintiffs to court for harassment and getting a restraining order against them, especially when you win, it's not outrageous conduct. Right? Like, that's not outrageous conduct. Although repeatedly contacting employers of defendants and admitting to it in court, like millions of times, not really millions, I'm being hyperbolic, right? A bunch of times, that may be extreme and outrageous. Putting someone at fear of losing their job because you're offended by their statements about you, or maybe the other person's statements about you. Like maybe contacting a school where the significant other of one of the plaintiffs works, someone who's completely unrelated to the plaintiff's actions that you're upset about, maybe contacting their school several times to try and get them fired. That might constitute extreme or outrageous behavior. Or impersonating a journalist to try and get information and to try and damage the employment relationship of another defendant. I mean, I'm not saying, Maddox, that you are Heather, but she might be bald and husky. That's all I'm saying. The intent to cause or disregard of a substantial probability of causing severe emotional distress is element 2. 3, a causal connection between the conduct and the injury. And 4, severe emotional distress. And that fourth one's really important. You have to demonstrate actual emotional distress, not a claim of emotional distress, not say, even under oath, that you have emotional distress. You have to show damage. You show emotional distress by going to therapy, and by putting up the bills as evidence, right? Like, you show that you lost a job, or you lost some sort of contract, or you were unable to perform some sort of duty because of what you went through. These are people, like intentional infliction of emotional distress people that are emotionally tortured, like someone pulls a gun and points it at their child. That's the intentional infliction of emotional distress, not someone making fun of you. Here, the alleged conduct that was allegedly undertaken by motion defendants does not satisfy the standard of extreme and outrageous. And it clearly does not. Not even close. To the contrary, the alleged offensive conduct that this court could, for purposes of this motion, construe as extreme and outrageous has allegedly been undertaken by defendants' followers, not Herrera or Foundation. Right? And that's in the complaint. Paragraphs 30 and 31, actually. Good job, Maddox. Motion defendants are not alleged to have sent death threats or undertaken any act to threaten plaintiff's safety that would be sufficient to satisfy this claim. As such, claim should be dismissed. Must be dismissed. Plaintiffs failed to state a claim for tortious interference with contract. Yep. Claim for tortious interference with contract requires 1, the existence of a valid contract between the plaintiff and the third party. Okay? 2, the defendant's knowledge of the contract. 3, defendant's intentional procurement of the third party's breach of the contract without justification. Without justification. That's an important part of this claim. I don't know if it's important to this. 4, actual breach of the contract. They have to breach a contract, not end it. And 5, damages resulting therefrom. An essential element is that the breach of contract would not have occurred but for the activities of the defendant. What's a but for? A but for is a matter of determining a cause. A cause of something. This would not have happened but for. This whiskey would be here but for my drinking it, right? Now, it's not to say that it's the proximate cause. Proximate cause is like what actually caused something. Because, I mean, ultimately, everything was caused by one event if you go back far enough. Right? The Big Bang or whatever created the universe caused everything in some abstract sort of way. But, anyway. Where were we? Sorry. Here, plaintiffs have failed to plead facts to support the vast majority of these elements. As an initial matter, plaintiffs have failed to plead any facts regarding the terms of any alleged contract with Harry's, Kindle and Hyde, or plaintiff's publisher, or whether those contracts were terminable at will or for a fixed term. Let me just go ahead and... I'll just go ahead and say it. In any sort of advertising or sponsorship contract, they're all terminable at will if the brand thinks that the brand is being put at risk. We see this all the time with any celebrity who screws up. They usually have some sort of morality clause, they're called, some sort of public image clause, where if you, are advertising some Nikes and you go on a rape spree, Nike's not obligated to keep paying you because you're likely to damage their brand by being associated with it. So they can end the contract, and that's not a breach. That's a termination of contract. So I can... as close as I can come to promising, Harry's and Kindle and Hyde had if they had an actual negotiated contract and not some sort of oral agreement. But even if they had an oral agreement, they would have an understanding that they weren't bound to keep advertising on the show. But yeah, they're terminable at will, guaranteed. It's a sponsorship for a podcast. Of course, it's terminable at will. Plaintiff has also failed to allege a breach of any of the alleged contracts. Right? They didn't say they were breached. They just said Harry's ended. Kendall and Hyde went out of business, by the way. That's not anybody's fault but theirs for failing to deliver products. I gotta ask, Maddox, please, have one of your shills, if they need to, comment in the comment section. Did you know the Kendall and Hyde guys personally? You're all from Salt Lake City and you're about the same age. Did you know them? Otherwise, their advertising on your network doesn't make any sense at all. With regards to Harry's, plaintiffs has only alleged that Harry's, quote, canceled its sponsorship, not that an agreement was breached. If Harry's had the right to terminate its relationship with plaintiff, and it did so, that is not a breach. Correct. Similarly, with regards to Kendall and Hyde, and plaintiff's publisher, plaintiff's complaint makes no allegations that any such alleged contracts with those parties were breached at all. And what they mean is, they don't even allege that the contracts ended. We know Kendall and Hyde ended because Kendall and Hyde ended. The book obviously is still being sold. It hasn't been pulled from the shelves, although I don't know why. Absent some misconduct, i.e. fraudulent representations, threats, or violation of a duty of fidelity, none of which are alleged here, quote, no liability has resulted to one whose actions have induced non-performance of a contract deemed to be voidable and thus unenforceable. Yeah. Plaintiff has similarly failed to plead that the motion defendants intentionally procured a breach of any alleged contracts. That's right. To the contrary, it appears plaintiffs allege that Herrera's fans allegedly spammed Harry's social media sites with accusations against plaintiff. With regards to plaintiff's book Fasterisk Whales, there does not seem to have been any alleged breach or interference with the relationship. To the contrary, it seems that the gravamen of plaintiff's complaint is that Herrera allegedly voiced his opinion that he did not like the book, and plaintiff is trying to blame bad sales on Herrera. And this is funny. Again, this is one of the sad things that this won't go to trial, is because we could get detailed numbers on the book sales in Discovery. And wouldn't that be funny? Wouldn't it be funny to see how just sad that has to be? Yeah. There's simply no facts pled here that any alleged agreements were breached, or given the third-party involvement that plaintiff has alleged, that any alleged breach would not have occurred but for the activities of the motion defendants. Plaintiffs failed to state a claim for tortious interference with business relations. Plaintiff's sixth cause of action is similarly deficiently pled and must be dismissed. The quote, tort of interference with business relations applies to those situations where the third party would have entered into or extended a contractual relationship with the plaintiff, but for the intentional and wrongful acts of the defendant. Plaintiff's claim falls woefully short of stating a claim for relief for this cause of action. Plaintiff baldly alleges that he had a valid relationship with a third party such as his fans, developers, and other individuals and companies. No, you don't. Without naming any of the actual persons or entities this claim refers to. Then, without alleging any supporting facts, plaintiff alleges, without any specificity as to what actions he complains of, that the defendants, quote, acted out of malice or used improper or illegal means that amounted to a crime or independent tort. Plaintiff has completely failed. They could have just stopped there. I mean, that could have been the first and last line of this whole thing, I think. To allege that any relationship was breached, or that but for any alleged unspecified malicious acts that he would have entered into any contracts or business relationships with any of these unnamed persons. In the case cited, Ivan Mogul Music Corp., plaintiff had to show that she would have entered the agreement into but for the malicious, fraudulent, and deceitful acts of defendants, and that defendants had no proper purpose. As none of the required elements of this claim has been pled, and this claim should be dismissed. They left out as such. As such, none of the Or they should have taken out this and. It's weird. All right. Plaintiff's claim for conversion should be dismissed. I mean, yeah, pretty much, right? The tort of conversion is established when one who owns and has the right to possession of personal property proves that the property is in the unauthorized possession of another who has acted to exclude the rights of the owner. Here again, plaintiff's complaint pleads no facts to support any allegations that motion defendants took possession of any alleged identifiable personal property to exclude the rights of the alleged owners. What did they take? As an initial matter, it is not clear what specific alleged property plaintiff's claim was converted, as plaintiffs have only alleged conversion of broad categories of information. Regardless, however, the gravamen of plaintiff's conversion claim appears to be that certain defendants allegedly published information about the plaintiffs on the internet that was obtained by other publicly available information or that was provided to them by third parties. It's from paragraph 176. However, these facts do not support a claim for conversion, and as such, plaintiff's seventh claim should be dismissed. Like, they're just playing badminton right now. Just batting them down, right? There's nothing here. Plaintiff's claim under New York General Business Law 349 and 350 should be dismissed for failure to state a claim. In order to state a claim under 349, a plaintiff must charge that the defendant has engaged in deceptive conduct that is consumer-oriented, causing injury to the plaintiff. General Business Law 350 similarly declares unlawful false advertising in the conduct of any business, trade, or commerce, or in the furnishing of any services in the state. Here, plaintiffs' claim under General Business Law 349 and 350 fail, as plaintiffs have failed to allege any facts to support the conclusion that any of the practices being challenged occurred within New York. Excuse me. Here, the motion defendants are not New York residents, and neither are plaintiffs. As such, there is no basis for the court to infer that any of the alleged challenged acts occurred in this state. Right. If you're out of state, suing in another state, you better tell them how it hurt you in the state you're suing in. Even if you're in state, you should tell them, because you should be thorough. You had 53 pages to do this. 53 pages. Oh my gosh. All right. Moreover, the alleged actions that are complained of in this count have nothing to do with consumer-oriented conduct or false advertising. To the contrary, plaintiff's complaint is wholly focused on the motion defendants allegedly, 1, having their followers disrupt plaintiffs' lives, 2, having their followers defame and harass them by sending posts and tweets, and 3, causing mental distress. However, none of this alleged conduct, even if true, is the type of consumer-oriented deceptive acts and unfair practices that 349 and 350 were enacted to guard against. As such, this claim too must be dismissed. Conclusion. For all the reasons set forth here and above, motion defendants respectfully request that the court dismiss this action against them. Done. That's it. I mean, that's the whole memorandum of law in support of the dismissal action. I don't remember if there's anything interesting in the Bozer affidavit. It's unfair for me to have to defend this action in New York. I don't go to New York and never ever go to New York. I don't pay income taxes in New York. I don't do any business in New York. Foundation Digital, neither Foundation Digital nor I have anything to do with the podcast entitled The Dick Show. This is actually interesting because Maddox said that Bozer and Baker have appeared on the podcast in the complaint. Under oath, he said this. I assumed that this must be true. Because I don't know. I figure Maddox might know these people and would know that they've been on the podcast in some capacity as a guest or whatever. And that Dick just didn't, he uses pseudonyms for some people. And so I figured maybe it was one of the pseudonym people. Nope. So Maddox, he lied in his complaint again. Neither Foundation Digital nor I do any work for the podcast, nor do either of us do any content creation or marketing for the podcast. Neither Foundation Digital nor I have any part in the writing, hosting, recording, production, editing, or distribution of the podcast. Podcast is a personal project of Dax Herrera's that is entirely separate from his work with Foundation Digital. Foundation Digital does not have any clients in New York, nor does it target business in New York as potential clients. Does not conduct business in New York. Foundation Digital does not maintain a physical office. That's just a mailing address. I also do not work out of that address. No one at that location is authorized to accept service on behalf of Foundation Digital or myself. It's just a UPS store where Foundation Digital receives mail. Foundation Digital has a separate agent, Business Filings Incorporated, that is authorized to accept service for Foundation Digital, and that entity is listed with the California Secretary of State. I'm not the host of the podcast. I have never appeared as a guest or speaker on the podcast, and I have nothing to do with its creation, production, marketing, or distribution. I have never met Plaintiff George Azunian. Whew. That's, it's not helping you out there, Maddox. Here's Dix. I don't live in New York. I don't go to New York. It's burdensome for me to go to New York. Separate from my work at Foundation Digital, I'm a satirist that is known under the stage name or pseudonym Dick Masterson, and under that I host a podcast called The Dick Show. I also have a website promoting my podcast located at thedickshow.com. Not dickshow.com. Thedickshow.com. My podcast is hosted, recorded, produced, and edited in my home office in California. Occasionally, other guests participate remotely. However, mostly my audio engineer Sean co-hosts the podcast with me. I have also occasionally done live shows, most recently in Chicago, Philadelphia, LA, but never in New York. Yeah, I don't target New York. I don't do anything in New York. Leave me alone in New York. One of my guest commenters, Asterios Kokonos, has appeared on the podcast several times. However, he is not under my employ. Before starting the Dick Show, I hosted a podcast along with George Uzunian, the plaintiff, who is another satirist known under the name Maddox, pen name Maddox. I've known George since 2008. Since I've known George, I believe, to the best of my knowledge, that he has either been a resident of California or Utah. However, I've never known him to live in New York or have any substantial relationships with New York. More about Foundation Digital. Like, these are, I mean, you can read these documents. I'm not going to go through them any more than I have, because they just say the same things that's in the motions, right? We don't have any connection to New York. This is stupid. Maddox is stupid. They should just say that too. By the way, I believe Maddox is stupid. So here's the affirmation of Sarah Matson. This is short. The only real reason that this affirmation exists is, it's submitted in support of defendant's motion to dismiss, and they attach the exhibits to this this affirmation. And the affirmation, says that, I'm familiar with the facts and circumstances of this case based on my personal handling of this file. Here are these exhibits, which are true and correct copies of these things. And then finally, wherefore moving defendants respectfully requests that this court grant moving defendants' motion to dismiss, and for any such further relief as this court deems just and proper. There's some conversation about whether that includes attorney's fees or not. I don't know. Don't know how you ask for attorney's fees in New York. In Minnesota, this would not be sufficient to request attorney's fees. In Minnesota, you have to specifically move for attorney's fees, and then you have to provide an affidavit laying out the basis for your attorney's fees, right? You have to lay out why you charged what you charged, basically give an accounting by hour and what your hourly rate is, and you have to justify the hourly rate and all that stuff. So I don't know. I don't know if that's included. My thinking is that they just want this dismissed and to go away. And going after attorney's fees from Maddox, I mean, it sounds appealing and fun, but if you have to appear and argue, it costs more. And what if you lose and waste everybody's time? getting it done is fast. If they can get it dismissed here. Now, if this thing goes to trial, or if it goes beyond these initial dismissal motions, absolutely, if they're going to have to be in court anyway, they should be filing for attorney's fees, assuming you're able to do it under New York law. Not an expert. I have not really researched the attorney fee question, because I think that their best bet is probably just getting out of this thing rather than trying to scrape together a judgment against Maddox in New York. And remember, like, I mean, Maddox has availed himself of the forum by requesting to sue in the forum. But if your entire argument is that they don't have jurisdiction over you and they wouldn't even have jurisdiction over the plaintiffs, then to go and ask for attorney's fees rather than just having it dismissed, I mean, you can do it, but there's a subtle psychology to just saying this doesn't belong here. None of this belongs here. Just let us go. That's a way to get this thing in your motion to dismiss. You have to consider things like that, right? Like if you're trying to just get something thrown out, let the judge just throw it out and forget about everything. Make it as easy as possible. If the judge can do that, you're more likely to do it. If they then have to decide on attorney's fees and maybe have a motion hearing on it when you wanted to dismiss it, but now they've got to do all that work, it's one less, it's not much, right? But it's one less reason for them to throw it out. And you sometimes don't want that. So that's probably legal strategy. You know, if the court really gets mad at Maddox, I guess they could. I mean, the court can authorize the attorney's fees. They can go ahead and do that all they want, if that's allowed under New York law. But you don't overplay your hand, man. Sometimes just getting out of things is the way to go. So that's it. I mean, that's what I got for today. Again, the complaint is, or not the complaint, this motion to dismiss and the memorandum supporting it are well laid out documents. It's a much better argument than what's put forth in the complaint. It's much more convenient to the forum. The judge or the poor sap clerks who have to read this and go through it are going to find this document much more appealing, well-researched, thorough. It should be much more persuasive. The sad thing is that, like, the clerk or the judge who's reading the complaint is going to sit there and they're going to get the complaint and they're going to read it and they're going to think it was written by someone who's self-represented, and then they're going to get to the end and see it signed by a lawyer, and they might just hang themselves at that point and go, what happened? What is this nonsense? But I don't know. But in any case, I think we'll see a full dismissal as to Dick, Foundation Digital, and Bozer. We should. Really should. There's some guilty pleasure if it does go to trial, because discovery will produce some funny things. But I don't think that's going to happen. And I would much rather see these guys left alone. Right? Like, no one needs to go through this. This document, 25 pages, it took me 2 hours to read it. This document probably cost $2,000. I don't know. It's well researched. It's long. This costs a significant amount of money. And to see them have to spend this kind of money to defend against just utter garbage, that's not cool. It's not cool. Maddox, you're a dingus for doing this. I hope Rucka gets mad at you and beats you in your studio or something. I don't know. Whatever. Anyway, guys, as more documents drop, of course, I will keep covering this. We've got the trademark videos as well. If you haven't checked them out, check them out. I'll have a trademark video coming out soon, which will cover Dick's complaint in the trademark suit, counter his petition opposing Maddox's trademark. That'll be coming out soon. That's pretty interesting. If anyone out there happened to snap the emails before the court took them away, let me know. I'm interested in them. So if anybody happened to just be snapping copies of documents, let me know. If you've got a copy of those emails, I would love to look at them and consider the legality of reading them. So, you know, whatever. I imagine someone out there has snapped a screenshot of those things when they went up, because some people snap screenshots of everything, but I don't know. So, yeah, contact me if you got them. I'd be really interested in taking a look. But otherwise, you know, definitely going to cover the Dick's complaint very soon. And then other videos, I do other videos unrelated to Maddox and Dick. Please check them out if you're interested in legal topics. If you have legal topics to discuss, check my Patreon page. You can leave me a message on there, or send me a message on Facebook. I'm happy to explore new things or learn new things. One of the, I guess, preview some stuff I've got coming up. State versus Smith is a case in Minnesota in which a homeowner was allegedly defending himself against robbery from some people, and he kind of shot him, and then he was charged with murder. And some people are curious whether that's, you know, like a castle doctrine type thing, or if that was justified murder. And so I'll be talking about that. And then, like I said, Costanza versus Seinfeld. I think I might do a celebrity lawsuit section, because sometimes they're funny, right? And there's interesting things, like for example, Daryl Hall from Hall & Oates. Daryl, I think. Anyway, Hall from Hall & Oates. He has a case here in Minnesota that's a leading case on child support. So, you know, because he got some lady pregnant here in Minnesota, and then, you know, he's strolled out because he's Hall from Hall & Oates. I don't know if that had anything to do with the song Maneater, but maybe. But anyway, so, you know, there's that case, and then that we may go through, and then any of these lawsuits against celebrities, I'll probably do a series on them at some point. And then I've got just stuff about general ramblings, like that Wichita police shooting that was absolutely bogus. The shooting of Shaver that was down in Arizona. Police violence is something that's kind of been on my mind a lot lately. So yeah, check them out. Tell me what you're interested in seeing. I love the feedback. I love conversing with you guys in the comments. So cheers. Y'all have a good night. Hope you enjoy this stuff, and keep watching.